Mr. Grimmerthy, I know you just walked in. Are you ready to go?
I'm ready on Coon and Watkins, Judge, and I appreciate the court giving me 15 minutes. I had a pretty quick last year. I'm going to need a minute with Mr. Welch, Judge.
All they have is that user district and password court 2022. Okay.
Yeah. Yes.
Like if not,
No. So, yeah, so yeah.
Okay, Mr. Grimmerthy, which one were you ready on now?
Watkins and Coon, Judge.
People versus Amanda Watkins, case number 235186.
Eric, on behalf of the people.
Thank you, Honorable Grimmerthy. I'm here on behalf of Ms. Watkins. She's here. She's sitting for the right, Judge.
Okay. I have on the docket to review sentencing, so I'm not sure, Mr. Grimmerthy, can tell me what we need to do today.
Yes, Judge, Ms. Watkins was previously sentenced. She was in jail. She was pregnant at the time. I think the court was aware of that. And the jail nurse had some concerns about her pregnancy and some issues. And then we stipulated to have her out of jail. She's still pregnant. Ms. Watkins will indicate that this is the longest she's ever been pregnant, but given her prior pregnancies, they've all been early. She's healthy. She's still carrying. She meets with her probation officer. She's doing things. So I would just ask that we still adjourn and review sentencing again in another 90 days or so. And can come back in the meanwhile. She's still under the sentence of the court. There is a jail component, but she's still pregnant.
All right, Ms. Koch.
I mean, I don't know anything about her pregnancy. She was ordered to 6 months in jail on September 8th. Released from jail on or about 9/26 because of a high-risk pregnancy. And so the rest of her jail sentence is remaining, but if she's still pregnant, we still have the same concerns. I don't know if we have to wait 90 days, but I don't know what her due date is, so.
Do you have a due date?
I do, it's December 22nd.
Okay. All right. The court will set this for another hearing in 90 days. I think that's a reasonable amount of time given the circumstances. And then we'll go forward at that time. Mr. Grimmerthy, anything further we need to address today?
No, sir. Just
So,
keep in touch with me.
No, thank you.
Thank you.
all right, thank you.
Thank you.
I'll let you know when the due date is.
Okay, sounds good, thanks.
Mr. Coon is well, Judge.
Okay, People versus Coon, case number 235256.
And thank you, Honorable Grimmerthy, and behalf of Mr. Coon. Mr. Coon's here seated to my right, Judge.
And Mr. Grimmerthy, how did we want to proceed with Mr. Coon's file today?
Judge, this is our first status conference in circuit court. I've had some discussions with Ms. Koch's office regarding the radar and what initially brought Mr. Coon to the police's attention. I've received some compliance that the radar wasn't compliant, but I don't have anything indicating the speed limit and what brought that stop. I think we need to further investigate that issue, because I think that is the crux of whether the stop was a lawful stop, because then the altercation that occurred was in Mr. Coon's garage, which would bring up the issue of Marino, that whether it was a lawful arrest that Mr. Coon subjectively believed to be true or not. So I would ask that the court give me at least 45 days to either get the proper radar numbers as to what it was run. If that's not available, we have a motion hearing and the court make further decisions from there.
All right, Ms. Koch.
We have given Mr. Grimmerthy everything that's available. I mean, there are things that he wants that are not, they're not printouts. They just check them. There isn't anything else he can get, but if the court allows him time to file a motion, I have no objection.
Okay. The court will set this for a status conference plea hearing on its mid-January motion day, so that'll be about 6 weeks.
Right.
I think that's enough time if there's going to be a motion to get that filed and set for hearing. If there haven't been any motions filed, has there been a plea offer in this case, Ms. Coke?
There has, and then a plea offer was for an attempt RNO. Sorry. Yep, it's an attempt RNO.
It is an attempt, I don't know, Mr. Coon's aware and he's rejected that offer.
Okay, so that next hearing would be a plea cutoff. So Mr. Coon, to the extent that you want to consider that offer further, I would need you to have made a final decision.
I have done nothing wrong, Your Honor. Nothing.
Okay, I'm not here to argue with you about what happened right now.
I didn't say anything about that. I just said I didn't do anything wrong, so I'm not taking a plea on nothing.
Okay, what I'm telling you is, to the extent that you want to further consider it.
Just listen to what he said.
Okay.
Yeah, I wanted to make sure you understand your options.
Yes,
Okay?
sir.
That's all. To the extent that you want to further consider it, or there might be a different offer, or who knows what could happen between now and the middle of January that might result in you wanting to change your mind about that. Life's unpredictable, right? Anything could happen. I want to make sure you understand that if you wanted to do that, that would be the date to do that, okay? And once you make a decision on that date, that would be a final decision. You don't have to make that decision today. So you have that option. At that next hearing, if there is no plea, then we will set for trial and then we'll go forward at that point. Ms. Koch, any other dates that I can address for you today?
No, Your Honor.
Mr. Gerber?
Judge, if I did file that motion, clearly that motion would then be heard outside of that plea. So will the court then extend that plea cutoff date based on whatever the ruling is, in case there's a motion filed in the court?
Right, yeah, I just, if we're gonna have a motion, I want it to be set for hearing. Or at least filed within that period of
Okay.
time so that we know we have that issue to get resolved.
Right, and then I just want to make sure that when I explain that to Mr. Coon, that timeframe will extend out if that motion is filed.
Yes.
Okay.
Yeah.
I'll
Okay,
call you and talk to you about
okay, thank you, that's all for today.
I wanted to split.
I'll call you and talk about
All right.
it.
Okay, and Mr. Gerber, you said you needed a chance to speak with Mr. Welch.
I did, there was a objection that was filed, I just wanted to clarify some dates with Mr. Welch, so I need a couple of minutes with Mr. Welch first.
Okay, we'll take a short recess, we'll come back on the record in about 10 minutes. Okay, we're on the record in People versus James Welch, case number 235260. If I could have counsel put your appearances on.
Sierra Cook on behalf of the people.
Thank you, Honorable Abby Gordon, on behalf of Mr. Welch, who's just seated to my right.
All right, this is the date and time set for sentencing in this matter. Mr. Germer already referenced it, but Mr. Welch is present here in the courtroom today. Mr. Welch, have you had a chance to go through the pre-sentence report and talk to Mr. Germer about that?
Yes.
Mr. Germer, are there any additions, deletions, or corrections that need to be made to that report?
No, Judge.
Are there any challenges to the scoring of the guidelines?
Judge, we didn't file any objections to the guidelines. We think it's appropriate at 0 to 17, but I would orally like to respond to the objection filed by the prosecution.
Okay, Ms. Koch, before we get to your scoring challenge, are there any additions, deletions, or corrections?
No, Your Honor.
And your challenges to OB-19, I had a chance to review that along with the case law that you submitted. Any oral argument in support of that?
Your Honor, I couldn't find any case law on point since he technically wasn't on bond yet because we couldn't get him on bond because he couldn't show up for arraignment. I couldn't find any case law specifically dealing with that issue. So the only case I could find on was the ones once they had been arrested and arraigned, and then so that's what I cited, but I don't have anything additional. Thank you.
And based on that, I would ask that OB-19 not be scored because Mr. Welch at that time was not arraigned and wasn't in bond status. So I think that would be improper for the court to assess those points.
All right, based on the lack of any clear authority in support of that, and first of all, I don't think this is a factual issue. So the court, I don't think, needs to make any kind of judicial fact findings here in order to rule on this. I think it's a legal issue as to whether or not OB-19 is meant under the statute to apply to this circumstance. The statute doesn't specifically reference this, and without any case law covering this specific issue, published or unpublished, and looking at this, I think as the party challenging the scoring is their burden to provide the basis. The court can't find that if OB-19 is scored now is improper. So the court will deny the challenges to this case. And OB-19 will remain at 0, which leaves us still with the guidelines of 0 to 17. Ms. Koch, any other challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, the court's aware of the circumstances around this case. We ask the court to follow the recommendation of MDOC. Thank you.
Thank you, Mr. Germer.
Judge, I don't think the recommendation is not fair or anything over the edge on this matter for Mr. Welch. I would ask you to follow it, but I would also advise the court if the court is going to let Mr. Welch out and give him some time instead of the balance for the 109 days that he has and the 150 days of recommendation. He is homeless. He's trying to find housing. He has housing at this point set up. His girlfriend is where, or at least he tells me that's where he's going to reside. And I know that given the weather, if Mr. Welch is able to get out sooner before it does get even colder, would be able to then at least start securing housing, deal with Department of Corrections, and would have a proper place to at least get his housing situated. Other than that, I know Mr. Welch has some unpaid fines and costs from his district court matter. He is unemployed, but I think he's going to find employment and work towards
I
finding
have
some.
employment now.
Well, and then I would just ask you to update the court,
Yeah,
but at least he indicates now he does have employment, so I think he's going to at least start working towards paying those fines and costs as well.
Okay, thank you. For this part of the hearing, Mr. Welch, may you stand. Is there anything that you wanted to say today? All right. The court has had a chance to review the pre-sentence report. There's a lot of information in there about your background and your circumstances, as well as what happened in this particular case. And then all of that taken into account along with what the lawyers had to say here on the record. I do think the recommendation is appropriate. 150 days is in the middle of the guidelines, which are, as you heard, 0 to 17. So I think it's a reasonable sentence. I think it accounts for your conduct in this case as well as your past record. I will say, you know, you've been on probation a couple of times. You've had a few jail sentences. As you can see, your guidelines are now starting to creep up. I think future convictions are probably going to result in prison recommendations. So to the extent that you can take some actions now to kind of address your underlying problem, I think now is the time to do it, because otherwise, the next time I think you're gonna wind up going to prison,
I understand, sir.
which is a completely different experience than county jail. So the court is going to sentence you to 150 days in the Crawford County Jail. You do have credit for 109 days served. The court will order a crime victims assessment of $130, court costs of $325, attorney fees of $350, and the state cost of $68. You do have the ability to seek an appeal of the sentence, and Mr. Gurmurthy, have you been able to provide those appellate rights to Mr. Welch?
Yes, Judge, I did go over his appellate paperwork with him. He's acknowledged receipt of the same as well.
Ms. Koch, anything further on this file today?
Thank you.
Mr. Gurmurthy?
No, sir, thank you.
Mr. Welch, you are remaining.
Thanks, sir. Thank you.
If Mr. Beck is here, if you would like to, might be the roll.
Okay, People versus Beck, case number,
Which one? Which one?
Aaron Beck.
Aaron Beck.
Yes.
Oh, I see. We have
It's two
two Becks, yeah. Aaron Beck, case number 235265. Record should reflect Mr. Beck is present here in the courtroom today. If I could have counsel put your appearances on.
Here, go back to people.
Thank you, Robert Gurmurthy, on behalf of Mr. Beck, who was here standing to my right.
Okay. Mr. Gurmurthy, can you tell me where things are at with this file?
Yes, Judge, again, this is our first felony status conference here in circuit court. We had a prelim that was run in this matter. His brother was the co-defendant in this matter. Both Mr. Thompson and I jointly ran that preliminary exam. I have requested transcripts. I would ask the court to hold a second status conference once we have the transcripts, or at least give me time in case I have to file any motions once we receive the transcripts. And if we don't, we can just hold that as a pretrial at that point.
Okay, Ms. Koch.
And I would be fine with that track.
Okay, so Mr. Gurmurthy, I'm going to set this for a status conference in 60 days. I'm going to make that a plea and motion cutoff. So it should be enough time to get the transcript and file any motions. So we'll proceed on that date. Mr. Gurmurthy, any other scheduling matters for your side today?
No, sir.
Ms. Koch?
No, thank you.
Okay. So, Mr. Beck, it's just important that you stay in touch with Mr. Gurmurthy over the next 2 months so that you're aware of what's happening with your case and you're ready to proceed at that next hearing, okay?
Yes, sir.
Thank you.
Thank you.
You're gonna call me for the 15th, right?
Yeah.
Don't forget.
Okay.
I'm ready, Mr. Schlapp.
People versus Schaaf, case number 23527. It should reflect Mr. Schlapp's present in court today.
Thank you, Robert Gurmurthy, on behalf of Mr. Schlaff, who's just standing to my right. And first, I'd really appreciate the court taking this matter on a short notice and the prosecutor waiving the notice requirements. This was just an emergency motion that we filed that Mr. Schlaff's mother passed away over the weekend. Mother-in-law passed away over the weekend. And Mr. Schlaff indicates that there's about $3,600 of funeral costs that have come up. He would like to have his bond reinstated, or the court at least give him 30 days until he comes back for sentencing. So he can at least be with his family to the time frame of mourning and raising some funds to get a funeral paid for.
Thank you, Ms. Koch.
He is set for sentencing next week. I'm looking at the recommendation right now to see what it says, but
It is a jail recommendation with the sentencing judge.
probation for 2 years.
It should be-
I think it's appropriate. It's hard when somebody dies, but we have people that go through it all the time. I don't know that mother-in-law is sufficient for a release from jail. The recommendations for jail is 120 days with 30 days served. Remains suspended if he completes the Lion's Den or any other inpatient treatment. I don't know anything about whether he's tried to make those accommodations.
Okay, so you're opposing.
I don't think that's appropriate. We've had a really bad that time with people being released for rehab and different furloughs, but if the court allows it, then we'd ask for it to be a very short furlough.
And he's not asking for rehab, he's just asking regarding the funeral, and we just got the recommendation 2 days ago, I know he hasn't seen it yet. But we know there's a jail component, and he will be here for his sentencing, there'll be no failure to appear, or he hasn't shown up to court, that hasn't been an issue, and in fact, he was at court last time while, we realized there was a bench warrant on the second file, the R&L file. And the court revoked his bond. He took a plea at that point, knowing that that was going to happen. So I don't see any issues with failure to appear, Judge. But I leave that in the court's discretion. This was just over the weekend. She passed away. She was ill, and we wanted to get that in front of the court.
Understand, Mr. Schaaf. This happens from time to time. Unfortunately, when people are incarcerated, things with family happen during that period of time, and unfortunately, the court simply can't just grant furloughs every time somebody has a family issue, and I'm sorry for the loss of your family, I really am. But that's just not a reason for the court to grant a furlough in this case, and it's part of the consequences of engaging in wrongful activity is you don't have the ability to be there for family, and that's a consequence, unfortunately, that they also have to pay for things that you've done.
Okay.
So the court is not going to grant the relief requested. Mr. Gurmurthy, since this was filed as a motion, if you could just prepare an order reflecting the ruling of the court so that we have that in the court file.
Yes, I can do that, Judge.
Thank you. That's all for today.
Sorry, come see you. The recommendation.
Okay.
Don't do that.
I'm not sure about Mr. Melon. I have not heard if he's still in rehab, if he's appearing in Zoom, if he's out of rehab.
Mr. Gurmurthy, we're going to call People versus Melon.
Yes, Mr. Melon is out of rehab.
All right, this is case number 235262. I can accept counsel with your appearance on.
Your on behalf of people.
Thank you, Webb, on behalf of Mr. Melon.
Okay, Mr. Gurmurthy, what is your information on Mr. First, I want to note for the record, this was set for 9:30. It's now 9:48. I don't believe Mr. Melon's present here in the courtroom. He has not tried to sign it. So record should reflect that.
I don't know if that's Mr. Melon. No, that is not, that's not Mr. Melon. Judge, if I could just check in the hallway.
Sure.
I know there was a jury trial. I don't know if you went to the wrong courtroom.
Okay.
Be right back. Just for the record, we are in the district courtroom, so there's a jury trial in the circuit courtroom, so I did poke my head at the circuit courtroom. Mr. Melon is not in the circuit courtroom. I've had good contact with Mr. Melon, albeit it's not the greatest contact. Mr. Melon has some different theories of his matter. Regardless of that, Mr. Melon was aware of today's date. He was in rehab previously. I did receive a letter from Bear River Health that he was discharged from rehab and had some medical issues. And Mr. Melon did fax me some medical documentation regarding his medical issues from Friday of last week. I did ask Ms. Cope if she would stipulate to an adjournment. She indicated that she would not, and we're here. And I indicated to Mr. Melon that we still had court. I just don't know if his medical obligations have somehow interfered in his appearance in court. He's appeared before. He's always maintained phone contact with me. I know he's spoken with Ms. Anderson. I believe she's on Zoom as well. But he's kept in touch with her as well. So I would ask that we set this for a show cause rather than issue a bench warrant.
Thank you, Ms. Koch.
Yeah, I don't have any specific notes about medical issue. I review, normally if they have like something major, I don't have that problem. But I don't recall the exact nature of why I said that, but if the court wants to do a show cause, I understand.
All right, I think it appears that Mr. Melon has not failed to appear in this file up until now. So based on that, the court will set this for a show cause at the court's next date. And then Mr. Gurmurthy, if you can just continue to try to communicate with him. And once we have that date, confirm that he's aware of that.
Yes.
Thank you.
Thank you.
Is that your last file, Mr. Germer?
That was just, thank you.
Next hearing set for 10 o'clock with Mr. Webb. We're about 10 minutes ahead of schedule, so we'll take a short recess and back on the record.
Thank you.
Is this Mr. Webb?
This is, thank you.
All right, we're on the record in People versus Webb, case number 235246. Right, have counsel put your appearances on.
Your Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant Douglas Webb. Your Honor, we'd like to enter a plea today. There's been a plea offer made, dismissal, count 1, possession of controlled substance, cocaine, in exchange for a guilty plea to maintaining a drug vehicle. That's a 2-year felony, Your Honor. It would be a no contest plea on the basis of potential civil liability. That's our request, Your Honor.
Thank you. Ms. Koch, is that a correct statement of the plea offer?
It is, Your Honor. The maximum fine is technically a high court misdemeanor, but for Michigan purposes, it's a felony. 2-year and or $25,000 is the max. We have filed the amended information.
Okay. Thank you. Mr. Webb, have you had a chance to talk to Mr. Thompson about this plea? Is that how you want to proceed today? Okay. Can you stand, please? Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Thank you. Mr. Webb, are you currently on any probation or parole? And you understand, as Ms. Koch just indicated, the maximum possible penalty that you could face for this charge is up to 2 years and or a $25,000 fine.
Yes.
With that in mind, what is your plea to that charge today? Okay. Your attorney indicated that you were going to plead no contest.
Yes, sir.
Is that correct?
Yes, sir.
Okay. So I'm going to go through your rights with you. You do have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading no contest.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you'd have to ask the next higher court up, the Court of Appeals, to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead no contest? Has anyone promised you anything other than what was said here in court?
No.
Is it your own free choice to enter this plea today?
Yes.
Right. I have Crawford County Sheriff's Report number 231376. Ms. Koch, have you reviewed that report?
I have,
And do you agree that the information contained within that report would provide a factual basis?
yes, Your Honor.
And Mr. Thompson, have you also reviewed that report?
I have.
And do you agree that it would provide a factual basis?
Yes, Your Honor.
Do you have any objection to the court admitting that as an exhibit and using that as a factual basis?
No, Your Honor.
Okay, thank you. Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Thompson, are you?
No, Your Honor.
Ms. Koch, are you satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Thompson.
Yes, Your Honor.
Mr. Webb, the court finds that your plea is knowing, voluntary. The court finds that based on the police report I referenced, that there is a factual basis to support a finding that you are guilty of that charge. The court's going to mark that police report as Court Exhibit 1 and admit that to the file as the factual basis. The court will accept your no contest plea. We'll set this matter for a sentencing hearing, and between now and the date of that hearing, you'll meet with somebody from the probation department for a pre-sentence report. Spoke anything further on this file today?
No, Your Honor.
Mr. Thompson.
Yes, Your Honor. We would ask the court to address bond. Mr. Webb has continued to be held on bond since his arrest on June 1st. So he's just at approximately 185 days today. As I indicated to the court earlier, it would be appropriate to be able to file a 180-day rule motion. I'm asking the court to instead consider bond today on an oral motion. He just pled to a 2-year offense. He has no prior felonies, Your Honor. He has, I believe, an attempted R&O and several low-level misdemeanors in his criminal history. I think it would be a very reasonable estimate of his exposure to think that the 6 months he served would be in the neighborhood of what he might serve or what he might be sentenced on this. The court would be aware his Turner maximum would be 16 months. But I don't think he's got the kind of record that would indicate that kind of sentencing. So I think if we release him now, there's a very good chance he has served his time. If not, he's local to the community. He would attend to sentencing and would do any additional time this court ordered. But I believe under those circumstances, it would be appropriate to consider granting him a PR bond at this time. Thank you.
Thank you, Ms. Coke.
He does only have, I think, 5 or 6 misdemeanors. There's some judicial segments that are missing, so some of those are old. I think it's appropriate. I don't think he's going to get more than 6 months, so I would not object to that.
Okay, the court is going to modify bond in this case to a personal recognizance bond, $500 personal recognizance bond. So Mr. Webb, you don't have to post any money to be released on bond, and you will be released on bond today. It's important, though, that you continue to stay in touch with Mr. Thompson so that you're prepared for that sentencing hearing and that you participate in that pre-sentence investigation process, okay? Do you have any questions about that at all? Mr. Thompson, anything further today?
Nothing further, Your Honor. Thank you.
Thank you. That's all for today. And I'm signing and bond paperwork.
All right, thank you. So you can go back to the jail. It's going to take some time to process that, but you'll be released today.
All right, cool.
All right, thank you.
Versus Jace Beck, case number 235266.
Sierra calls him, yeah.
All right, the record should reflect Mr. Beck is present here in the courtroom today. If I could have counsel put your appearances on.
Sierra calls on behalf of the people.
I'm sorry, Your Honor. This is Mr. Austin Beck.
This is Jace Beck.
It's Jace, it says Austin Jace Beck. It's kind of, his name's Austin, but the way it's on the docket is weird.
Okay.
Okay, his brother just has a case too, and I
Correct.
got confused for a second.
This is not Aaron.
Okay.
Aaron earlier. So is it, sir, is your first name Jace?
No, it's Austin.
Your first name's Austin, your middle name is Jace.
Yeah.
Okay. Get an ability to change that.
I have changed this and it keeps reverting it back. I
understand where I'm at.
Okay.
That wasn't how I knew him.
I've contacted Lansing. I'm like, I'm not sure why it will not keep the correct name.
Okay. All right, I'm satisfied we have the right person. Mr. Thompson, how do we want to proceed?
Your Honor, there's no offer in this case. We're asking the court to set a trial. I don't know if the prosecutor would intend to try these together. I will look at that situation if and when it arises.
Okay, jury trial,
Yes.
Ms. Coke, one day.
Yes, I am gonna ask that they be combined. It really doesn't make sense to do it twice. The facts are all intertwined.
Sure, okay. Mr. Thompson, are you gonna oppose any consolidation for trial? Or do you need time to consider that?
I need just a little bit of time to consider it. I will stipulate that there are certainly a lot of facts in common. This is one encounter with law enforcement at a home. I believe the evidence may show different defendants took different actions, but there is a common nexus. I agree with that representation.
I believe there are 3 co-defendants on this case, and the other one is not set until later. I don't know if it's in December or in January, just so you're aware of that.
Okay,
I can have a response by the third status, whoever that third person is, that status conference. I can let the prosecutor know my position at that time, Your Honor.
yeah, and I mean, I think just given the number of defendants here, Ms. Coke, I'm gonna ask that you file a motion so that all parties can respond, and if we have stipulations, that's great. But if not, then at least everyone has an opportunity to be heard on that.
Thank you. And I just want to wait to make sure they're all wanting a trial, but I will definitely do that.
Okay. Okay, so we'll have it set for a 1-day trial. At this point, if we're joining defendants and it needs to be longer, we can always address that. And then the court will, as based on its usual scheduling, the court will set up for a final status conference prior to the trial date, which will be the plea and motion cutoff. Mr. Thompson, any other dates I can address for your side on this one?
No, Your Honor, I will treat that as a motion cutoff. My client would like to request that for that next pretrial, if he could appear by Zoom. He lives some distance away. It was some hardship for him to make it today, but he did make it because that was how the court ordered that hearing be conducted. But he would ask you to attend by Zoom for the next hearing. Thank you.
Okay. I'll note for the record and to appear by Zoom for any status conferences.
Thank you, Your Honor. I appreciate it.
Okay, Ms. Koch, anything further I can address for your side today?
Thank you.
That's all for today, Mr. Beck.
Thank
Make
you.
sure you stay in touch with Mr. Thompson. Is Mr. Doran lodged?
He is not lodged, Your Honor. I will go see if he's in the lobby.
Okay, we're a little ahead of schedule.
Yes.
And Mr. Trish, it's that's Googan.
Calling
I am not sure
Okay.
where he's at.
one way or another.
Yes.
It's not Seago, right? Doing the Seago docket.
I think he's on Zoom, so I'm not sure if he's
Zip the room.
right where he's at.
This is Mr. Doran, Your Honor.
Okay. Mr. Doran, are you ready to go forward?
Yes, sir.
Okay. You can come right up to the table here, please.
That one I stick
Will you sit?
For now. We're on record in People versus Doran. This is case number 235226. The record should reflect Mr. Doran is present here in the courtroom today. If I could have counsel put your appearances on.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Anthony Doran.
Thank you, Mr. Doran. Have you had a chance to go through the pre-sentence report? And
Yes, Your Honor.
Have you had a chance to talk to Mr. Thompson about that?
Briefly, yes.
We're 9 minutes ahead of schedule, so if you need more time to talk to him, we can take a
I'll
break.
leave that up to my counselor.
I believe we're prepared to go, Your Honor.
Okay. All right, Mr. Thompson, are there any additions, deletions, or corrections?
I have two additions, Your Honor, if I could approach.
Yes.
I was just provided with this information from CMH.
Actually, I think I have that.
Oh, okay. All right.
2 pages.
Yes.
I just gave it to the court today.
Okay, yes, it just came in today. I think the delay is attributable to Mr. Doran's recent medical difficulties, which we had previously submitted paperwork. So we are asking court to accept that.
Okay, yep. Any other corrections, changes to the report?
No other corrections, Your Honor.
Any challenges to the scoring of the guidelines?
No challenges to the scoring, Your Honor.
Ms. Koch, any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
This case is hard. I know Mr. Doran from my job here, and he's a very nice person. The situation presents itself is very dangerous, and I can't imagine how Mr. Doran would be feeling if he got into an accident and hurt his child that was in the car. It's good that he's taking these steps on behalf of CMH. His guidelines are high because of his history. I looked at what they would be because he was kind of on the cusp of the 10 points for OB 18. And even if he didn't have that scoring, he'd still be at 5 to 23. I'd ask the court to sentence him within the guidelines. Thank you.
Thank you. Mr. Thompson?
Thank you, Your Honor. I would tend to echo the prosecutor's comments about his, his exposure and his scoring. I would ask the court to note much of this criminal history is quite old. You're looking at things from 1992 in here in terms of the controlled substance offense, the 2002, and then 2013 with some of these misdemeanors. He had the 2019, I believe, operating while intoxicated, and then this event, Your Honor. So the worst parts of his criminal history are quite old. Mr. Doran is a person who's taken responsibility. He's done everything he's supposed to do in this process. He's admitted what he did was wrong. He acknowledges that, so he's not someone who's sitting here saying, let me off because I didn't do anything wrong. He understands he's going to be punished, and he's prepared to accept that. He is working, though, to make himself a better person, a better father, a better member of the community. He's working with CMH. I think that could bear long-term fruit for Mr. Doran. He's not going to have a driver's license. He's not going to be able to drive, but he is an individual who can, when he's finished doing his time, he can be a parent. He can be a productive citizen. He's asking for the court to consider all that. This is not an individual who is, intent on breaking the law in the future. This is an individual who's, now not going to be able to drive, and he is not going to drive, and he is going to comply with whatever the court orders, Your Honor. I think the court was satisfied from the prior stipulation. The delay in getting here today, Mr. Doran was hospitalized for about 7 days. He had a tumor or a growth. He's appears to be on the other side of that. He actually looks much better than the last time I saw him. He told me they removed a pretty large mass from him, and so that is a medical concern he presents, but he advises that he's able to do jail time. He has some pretty common medications that I believe he'd be able to receive in the jail. So we're asking the court to consider all that and make sense. Thank you.
All right, thank you. Mr. Doran, if you could stand at this point, is there anything that you wanted to say to the court today?
That I learned a lot from this one. It was an eye-opener that my actions not only affected myself, but they affected the people that I love the most. And that was because of my actions. And that's what hurts the most. And I accept what you give me, because honestly, I deserve it. You know, hopefully I can keep staying positive and go forward, that this isn't a setback. It's just a hiccup that I got to go through for me to be a sobriety man and to continue on being a good, loving husband and love my children. That's about it. You know, I affected a lot more people than just myself.
All right, thank you.
Yes,
I did read through the report prior to today's hearing, so I'm familiar with this incident that brings you before the court today. There's also a lot of information in there about your background and your circumstances, so I have all of that. Also what the lawyers had to say, what you've had to say. I did receive about 20 minutes ago this report from CMH that I had a chance to read before we came on the record here. So I feel like I've got a good view of everything that's going on here, at least how it presents on paper anyway. And certainly on paper, this incident is really concerning. You know, driving in the vehicle with your daughter, then having her drive you at one point, is what the report reads. So not only did you put her in danger when you were operating the vehicle, but then now you've got an inexperienced driver with somebody who's really under the influence as their only guide in how to operate that vehicle safely. Just these are the situations that can really go bad really, really fast. And I think you and your family are really fortunate that nothing really bad happened that day. And just from reading the report, it sounds like this has been an issue that's been ongoing. And it sounds like in addition to whatever your consequences you're going to pay legally here, you've got some relationships that you need to work on and repair, particularly with your daughter, I think, based on what I read in the report anyway. So those are all concerning things to me. And when I read the report and looking at your guidelines, which called for almost up to, up to 2 years in prison, you're looking at some really significant potential penalties here. And I think based on your conduct, not unreasonable penalties. But I think there are some mitigating factors as well, based on the report from CMH, which I take very seriously. It does appear that you've really put some serious effort into dealing with this and trying to work on it so that when you do get done with your court proceedings, that you're going to be able to move on from this and work on repairing those relationships and making yourself better. So I think that does provide some hope that you're going to take this seriously. You're going to take this as a learning experience, that you're going to use it as a way to deal with your underlying issues and not repeat this kind of behavior. So I think it's appropriate to give you the opportunity to do that through probation, through a sanction here in the county jail, as opposed to the prison system, which unfortunately, I don't think would provide you with the kind of tools that you might get through your continued participation with CMH to help you move on from this. So I think the recommendation is well written. I think it takes all those factors into consideration, and I think it's an appropriate way to go forward. Certainly there needs to be an amount of jail time here based on the guidelines in and of themselves and based on your conduct. So I think a sentence at the lower end of the guidelines is appropriate. It provides a degree of punishment and deterrence, but also allows you to be released much earlier than a prison sentence so that you can be on probation and continue to get treatment and help. So the court is going to place you on probation for a period of 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions that are listed in the report. Of course, the most important that you not use or possess any alcoholic beverages or other intoxicants, and that you participate in and complete any treatment programs that are recommended to you. The court is going to order that you serve 10 months in the Crawford County Jail. You do have credit for 2 days served. A $130 crime victims assessment, court costs of $325, attorney fees of $350, a $68 state cost, $100 reimbursement for alcohol testing pursuant to statute, a fine of $500, and then a supervision fee while you're on probation of $30 per month. You do have the ability to seek an appeal of this sentence, and Mr. Thompson, if you can provide Mr. Doran with the appellate rights. Mr. Doran, these papers are going to explain to you how to seek an appeal if you wanted to do that.
Date and initial, as
As
well
well
as
as how
how
to
you
request a
receive.
court-appointed lawyer to help you with the appeal.
Go ahead, date and initial that to indicate you received it. You keep the bottom two copies. If you wanted to file appeal, you would use those documents. Just signing this just says you received it. Those are yours, Ms. Cook.
Can I add something, Your Honor?
Sure,
I am proud to say today I'm 39 days straight sober.
good.
And that was thanks to Miss Candace and my support team back there that it's been tough. I did not think that it was possible. And Miss Candace has given me the tools. Thanks to her, I owe her a lot and see them for giving me the help to understanding that I do have a problem.
Keep building that number.
I am, sir. That's why I haven't shaved. I excuse for not shaving. This is my sober face. This is my sober
Well, I
face.
hope to see you with a really long beard.
Me too, Your Honor. Me too.
Thank you.
Thank you, sir.
Yes.
You got this, sir.
Next hearing is set for 10:45. Take a short recess and we'll come back on the record at 10:45.
Ms. Googan is on her way over and Mr. Truth should be in soon.
All right, Mr. Trush, are you able to hear me okay?
Yes, Your Honor.
Thank you. So we're on the record in People versus April Googan. This is case number 225027 and 235246. The record should reflect Ms. Googan's present here in the courtroom today. If I could have counsel put your appearances on the record, please.
Sierra Cook against the people.
Thank you, Your Honor. Richard Trush appearing on behalf of Ms. Googan.
Thank you. This is a date and time set for sentencing in this matter. Ms. Googan, have you had a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, Your Honor.
Okay. Mr. Trush, and I know that the prosecutor has an objection to the scoring of OV-19, but before we address that, Mr. Trush, do you have any additions, deletions, or corrections?
I do not.
Any challenges from your side to the scoring?
No, Your Honor.
All right, Ms. Koch, as to the body of the report, any additions, deletions, or corrections?
No,
Any challenges to the scoring besides OV-19?
no.
Okay, and I did have a chance to review your objection to OV-19. Is there anything you wanted to state for the record in support of that?
No, I think it's pretty clear cut on this one. Thank you.
Thank you. Mr. Trush, did you have any argument with regard to OV-19?
No, Your Honor. I received that challenge. I think that the case law is pretty clear on that as well, unfortunately.
All right, so I had a chance to review the law cited by the prosecutor as well as my own research, and the court agrees that the case cited by Ms. Koch would apply in this circumstance, and that OV-19 would be properly scored at 10 points. And so that would then raise the OV score to 10, and that would result in a new scoring of the guidelines of 0 to 11. Is that correct, Ms. Koch?
It does, yes.
Mr. Trush, do you agree that with that new scoring, the guidelines would then be 0 to 11?
Yes, Your Honor.
Okay. Ms. Koch, anything for allocution on behalf of the people today?
I sort of struggled on this case. Ms. Googan did some things that were really good during her absconding period. She also did some things really bad. And as I previously stated, the apprehension team, and I don't know how they select who they're going to apprehend. It's not always the people I would select, but they called me so many times trying to find Ms. Googan, which was bizarre. She has no prior felonies. This is a meth case. We see lots of these meth cases. Her guidelines are 0 to 11. I don't know whether 60 days is sufficient or not for Ms. Googan. There was a discussion about a CMH diversion plan, but Ms. Googan's planning on maybe moving, and if she moves, CMH can't go with her, so they didn't do the diversion plan notice. But I do think that the court should score within the guidelines. Thank you.
Thank you. Mr. Trush, anything on behalf of Ms. Googan today?
Thank you, Your Honor. I agree with the prosecutor. I mean, this is a somewhat unique situation in which, you have this period of absconding from Ms. Googan, but frankly, a lot of what she's doing during that period, I think, is things that the court would generally consider to be good things. During that period, she completes, I think, an inpatient and outpatient program. She's in sober living. I mean, she's doing good things. I think the recommendation here is pretty reasonable in that it cuts the right balance, I think, between recognizing the the good things that she had done, also recognizing the bad things. I would just indicate to the court, she has 67 days and 66 days credit respectively. Obviously, the court isn't necessarily giving credit for the time that she spent in the rehab facility. I think the court can take that into account, though. I would suggest the court, I don't know that ordering additional jail beyond what she served serves a significant purpose to the court. One, because of the position she's at, where she's already gone through a rehab program. She was in a sober living house, tends to go back to a sober living house. And also from a very practical standpoint, with 66 days, once the court issues a sentence and good time credit is calculated to that 66 days, we're really talking about Ms. Googan serving about another 10 days before being released from the jail. So in a lot of ways, I mean, is that additional 10 days of punishment, what is achieved by that versus allowing her to get back into recovery and back into the good things that she was doing while she was out. So with that in mind, I would suggest to the court a sentence within the guidelines range is appropriate. I would suggest that a time served sentence with the 66 and 67 days respectively would be appropriate.
All right, thank you. Ms. Googan, if you could stand, please. Is there anything that you wanted to say to the court today?
I just, I didn't mean to abscond. I thought I had court May 9th and it was the 16th, and I couldn't quit doing drugs on my own. I tried. I didn't know what to do, so I just went to rehab. And rehab didn't, I told him that there's gonna be I knew that the second warrant was gonna be coming. And 5 months later, I got pulled over and I didn't have a warrant, and I was just, I was waiting around to get arrested, and I just, like I said, I couldn't quit on my own, so I just went to rehab. And when I got out of rehab, I went to Bay City where my family is. My uncle's a retired drill sergeant. I figured that was the best place for me to go. And I went to over 200 meetings in 90 days. I was volunteering with Fan Forum and harm reduction. And Monday through Friday, I went to Salvation Army, volunteered in their pantry. I went to AA meeting every day at 11, NA meeting every night at 7. I never missed, not one single day until I came here. I got a peer recovery coach and a substance abuse counselor. And I'm on medication for cravings with a psychiatric nurse. And I was just trying to do everything that I thought that you guys would make me do, before you made me do it. Because I didn't know I had a drug problem until I couldn't stop, basically. And it's just, I've lost everything. I've lost my house since I've been in here. I'm just having to start all over, and now I have this felony, and I'm just 1 semester away from the social work degree, and it's just really discouraging. And I've been in here for 67 days, with people not working a program, and it's just every day I'm in here, I just feel farther and farther away from, I just feel more, I don't want to say it, I don't want to jinx myself, but I just feel more at risk for relapse every day I'm in here. It's just the most, I don't know. I mean, it's jail, I understand that. I never really felt like a criminal. I just felt like, I understand the drugs are bad, and I understand why it's illegal, and I understand why it's a felony. I'm a good person. I just had a drug problem, and it's a disease is what I learned in rehab. It helps me to think that way because I don't want to think that I'm a bad person. I'm 50 years old, and I don't have any enemies. I've never done anybody wrong. I've never stole from anybody, or I'm a good mom, and grandkids. I've had 1 born since I've been in here, and I just want you to know that I know it looks bad on paper, but it was not my intention. And I'm kind of grateful it happened because I'm working a program now, and I feel, with the exception of this last couple of months, I really felt like maybe I want to go into the recovery field. It's the only thing I can think to do with my social work degree, that you can have a felony. Maybe I can help other people like Candace does for jail diversion. I don't know, but the rehab program I went to said if I could stay sober for 2 years, I was more than welcome to work there. So I'm going back to the sober living house. And I have be 8 months sober, December 20th, which is a miracle in itself. I don't know if you guys have noticed, but people don't really come off meth, but stats are like super low. So in that respect, I do kind of feel like a miracle. I do think the recovery community would benefit from my experience and education. And I just want to apologize and hope that you let me out of here. I could just get back to what I was doing. Thank you.
I did read through the report, so I'm familiar with kind of the arc that these two cases have taken, and you know, you're right, it does not look good on paper at all. But I also take into account what the lawyers have had to say, what you've had to say. So I try to look at all that information together and trying to determine what is an appropriate resolution to your two cases. There's certainly some negatives here. Again, you know, the court obviously wants to encourage people to seek treatment at whatever point, because that's really the long-term solution to this whole thing.
In my defense, I didn't really know that they were looking for me. I went to Bay City when I got out of rehab, and I told my mom to tell them that I was in rehab, and she said that she did that. And I mean, no one was calling me. I had the same phone number. I'm just gonna stop right now. I'm not trying to make any excuse. I'm not trying to make any excuses.
Let's not dig your hole any deeper than it is.
Thank you, sorry.
Because I don't buy that you didn't know any of this was going on.
No, I mean, I knew.
Yeah. So while the court encourages and has a reason to encourage people to seek treatment, the court also absolutely has an interest in making sure people do that the right way. And the right way to do it is not ignoring all the problems that you have in the orders of the court and your bond conditions to do that. I mean, there's a right way to do things, there's a wrong way to do things, and the court has an interest in enforcing its own orders and making sure that people comply and not make their own decisions about what they're going to do when they're under court supervision. And so that's what you did in this case. And I think had you not done that, because your guidelines are low and you don't have a felony record, you probably wouldn't have ever done any jail time. It probably would have been probation with jail held in abeyance. And so the time that you've done is a direct result of your own actions. And you need to be accountable for that. You need to accept that as part of the issue here that you need to continue working on as you go forward. That being said, I mean, there certainly are some mitigating factors here because as I think both counsel have acknowledged, you did a lot of the right things to help yourself long-term. And what that means to me as the sentencing judge is that it gives me an indication that you're on the right track and that there's some hope that you're going to continue to stay on the right track. And I think what's interesting is one of the things that you said was that you tried to do all the things you thought the court was going to make you do anyway. And it's always surprising to me that people wait until they're convicted of a felony and on probation to do those kind of things. Like, why don't you just do that? Why are you waiting for a court to make you do that? And when people come in front of the court and they say, I want you to, you know, I've never done rehab, I want you to order me to do it. Just do it. Don't wait to get in trouble and then decide that you're going to want somebody to make you do it, because that's really, I mean, I think people that are successful are the people that do it for their own reasons because they want to live a better life, not because they're under a condition of probation or being forced to do it by a court. So I say that again to say that I think that's an indication that, you know, you could be successful on probation and that you're doing this because you want to get better and not because you're being forced to do it. So all of that to say that I think the recommendation is appropriate. Again, I think based on the fact that you're avoiding these cases, that you were absconding on bond, I think there needs to be a penalty for that. I think there needs to be a consequence for that and a deterrent. But I think the recommendation of 90 days, which is at the low end of the guidelines, accomplishes that purpose. You've already got 67 days served on one, 66 on the other. And then I think a term of probation to provide a degree of supervision so that we monitor what you're doing and make sure that you're staying on the right track going forward. So I think it's a good recommendation and I agree with it. As to file 225027, count 3, the court's going to order that you serve 67 days in the Crawford County Jail with credit for 67 days served. The crime victim's assessment of $130, a $50 state cost. File number 235364, period of probation for 18 months. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. 90 days in the Crawford County Jail with credit for 66 days served on that file. The crime victim's assessment of 130 days. I'm sorry, $130. Court costs of $325, attorney fees of $350, and a state cost of $68. $30 supervision fee per month while you're on probation. You do have the ability to seek an appeal of the sentence. And Ms. Koch, would you mind helping with the appellate right there?
I already went over that with her. She did date and sign the receipt. I gave her the remaining 3 copies for record.
Okay. All right, Ms. Koch, anything further for the record today?
No, thank you.
Mr. Truish?
No, thank you, Your Honor.
Good luck to you going forward, Ms. Googan. I hope you stay on the right track. Next hearing set for 11:15. Court will be in recess until that time. Okay, sir, is your name John Castle?
Yes, sir.
Okay, we're on the record in People versus Castle, case number 225060. The record should reflect Mr. Castle's present here in court today. McFalda's here on behalf of the probation department. Mr. Thompson's here as a duty attorney. And Mr. Castle's present in the courtroom. Mr. Castle, you're before the court today based on a show cause alleging that you violated your probation. Do you understand why you're before the court today?
Yes, sir.
Okay. Couple of things I need to go through with regard to your rights. Number one, you do have the right to have a hearing as to whether or not you did violate your probation. You have the right to have an attorney present at that hearing and any other proceedings. If you can't afford an attorney, one would be appointed for you at public expense. If you are found guilty of count 2 of the alleged violations, and that's the allegation that you violated your probation by operating a motor vehicle under the influence of alcohol. If you're found guilty of that violation, it could subject you to the maximum possible penalty on your underlying charge, which is up to 1 year in jail. You understand that?
Yes, sir.
Okay. Mr. Thompson, have you had a chance to speak with Mr. Castle at all today?
I have not, Your Honor. I didn't, wasn't aware of this for whatever reason. I knew we had Miss Ford's arraignment. That's why I was in the courtroom, so I have not spoken with Mr. Castle.
Mr. Castle, are you going to be requesting a court-appointed lawyer?
Yes, sir.
Okay. Do you want to have a chance to talk to Mr. Thompson here as a court-appointed lawyer before we proceed further? You do? Okay.
I can speak with him on duty purposes, and I can also screen him, Your Honor, in
Okay.
case this is going forward.
Okay. So I'm going to have you just step over to the side there for a second, Mr. Castle. Is Ms. Ford present?
I go here in the courtroom. Would the court's preference be to call that and then allow me to speak with Mr. Castle?
Yes.
All right, yes, Your Honor, thank
Have you been appointed on Ms. Ford's case?
No, but I'm here for duty purposes.
Okay. So go ahead and have a seat, Mr. Castle, and then we'll take a break and give you an opportunity to speak with Mr. Thompson. But we'll go on the record in People versus Carrie Ford, 225139. This was set for a probation violation arraignment at 11:15. It's now 11:17. Ms. Ford has not appeared here in court today. She's not in the Zoom waiting room. Mr. McFalda, are you the agent on that one as well?
I am, Judge. I didn't actually expect Ms. Ford. I haven't seen her since she left inpatient treatment back in October. For the new laws, I wasn't able to do a warrant. I just set this for a show cause. There's already a warrant on another file for her leaving rehab and not returning to jail as ordered. So at this time, I just asked for a warrant, Judge.
Okay, Mr. Thompson.
I haven't received anything from Ms. Ford, Your Honor, so I don't have any position today.
Okay, so Mr. McFalda, the court would just request that you prepare a warrant, bench warrant for Ms. Ford for absconding. And we'll proceed further on her case when she's arrested and brought before the court. We'll take a short recess. Mr. Thompson, if you can just let Sarah know when you're ready to go on the record.
I will, thank you, Your Honor.
back on the record in People versus Castle. Mr. Thompson, did you have adequate opportunity to speak with Mr. Castle?
I did, Your Honor. I explained the charge and the maximum penalties he's facing. Mr. Castle's already been arraigned on the same set of allegations on a new misdemeanor complaint. Mr. Dylan Jaskowski's been appointed as his attorney. I'm going to recommend that Mr. Castle request a hearing, and then I'm going to appoint Mr. Jaskowski to represent him in this matter. We'll see how, if the two cases can work themselves out.
Okay, so the court will enter a not guilty plea on behalf of Mr. Castle. Did you want to set this out further, like 60 or 90 days?
I think that'd be appropriate. Allow the district court proceedings to continue. He's been arraigned, but his pretrial and jury status conferences have not occurred.
Okay, Mr. McFalda, is there any objection to that?
No, Judge.
Okay, so the court will enter a not guilty plea. We'll set this out 90 days for a hearing. The court will refer it to Mr. Thompson's office for appointment of counsel for Mr. Castle. And then in terms of bond, Mr. McFalda?
Judge, I just asked for a PR bond, and Mr. Castle's been reporting to me. He's provided some verification that of his employment, which I was already aware of. He also been attending some AA meetings, and he's now enrolled himself in Grace Center for outpatient treatment. So unless there's any type of further violation, I just asked for a PR.
Your Honor, just in terms of bond, Mr. Castle did want me to advise the court he is 40 days sober, so he is committed to that, and I believe that would support the request for a PR bond. Thank you.
Okay, so the court will set bond as a $500 personal recognizance bond. So Mr. Castle, you don't have to post any money today, but you do have to continue to comply with all the terms of your probation, okay? And of course, make sure that you stay in touch with Mr. McFalda as we go forward. Mr. McFalda, anything further we need to address on this case today?
No, Judge.
Mr. Thompson?
Nothing further. Thank you, Your Honor.
Mr. Castle, do you have any questions about how we're going to go forward? Okay, thank you. That's all for today.
Thank you.
I think that concludes our morning docket. Yeah.
Yes, Judge.
Okay, court will be in recess until 1:30.
Dylan is.
Kid.
He's taking.
Sarah, I'm gonna leave my computer in here.
Okay.
Is that fine?
Yeah, because I'm
Well, I just have a couple